litigation, I'm going to know what to do with it. Here he comes. And our colleague Karen, who is this sounds like an Abbott Costello routine, who is somebody got it. One of our patent lawyer colleagues, also in the Silicon Valley. And what these speakers will do now, since we're gradually sort of narrowing the focus, whether you're a startup company or an established company, if you're thinking about doing things in China and your crown jewels are intellectual property, which is the case for so many companies in the Silicon Valley, the question always arises, what is the Chinese intellectual property protection regime? How do you protect yourself? How much can you count on the legal protections in China to maintain the confidentiality of what's so important to your company? So David, let me turn it over to you.
Thanks, Tom. My name is David Jakopin. I'm a partner at Pillsbury in our IP group. My practice over 25 years that I've been practicing now has spanned from sort of patent strategy to patent litigation to working with corporate folks like Tom, to working with our China groups in sort of the office's formation. And so over the years, I've seen sort of a whole number of different areas. I continue to practice in those. My emphasis tends to be the litigation, where everything has gone wrong. That tends to be what people end up paying a lot of money for. That's going to be the very last slide that you see tonight, because my talk is primarily directed to the entrepreneurs in the room, all the ones who raised their hands, because what I'm going to be trying to talk about is how to do things right from the beginning to give yourself the best chance of success sort of as you go along the road. That being said, as an IP attorney, I'm not an IP attorney who thinks that patents are everything and you should patent everything and spend $10 million on me so you have nothing left next year, as was an example given a little bit earlier. You have to be practical, and in fact, I kind of look at patents, for instance, as the sprinkles on the icing on the cake. You've got to have a good team. You've got to have good technology. You've got to have everything else in place. And if you do that, and if you've actually done all of your patent filings early on and right, you can get some really hefty margins for those sprinkles at the end of the rainbow, okay? But you've got to get there first. But you've got to plant the seeds at the beginning in order to get to that place. And as part of that, you actually have to really understand what are the different forms of legitimate intellectual property that are there, so that you can actually then really understand the tools and the differences between them and to put them right. I'm going to be handing the mic over to Karen, my colleague, to sort of go over just these different kinds of IP, and then I'm going to take it back and talk about some sort of basic principles that you can use with respect to them. But do keep in mind that you want to make sure to be sort of getting these things right from the beginning. In the US, we have a system overall that tends to be pretty lenient. While I've heard Tom, my partner, say that the laws in China are sort of fluid, that is true, but as it relates to China and IP specifically, if you miss things, if there's gaps in your IP, there's another billion people who are going to exploit those gaps and figure out how to fill them themselves rather than it being you to take advantage of your company. And so, sort of with that, I'm going to hand the mic over, and Karen's going to outline for you sort of the formal different kinds of IP that you're going to want to be looking at, and some of the differences between how that's done in China versus the US.
Thanks, David. Good afternoon. So I will do a quick China IP overview. Just to a little bit history, the US IP law, specifically patent law, has over 200 years history, whereas in China, we're talking about 20 years history. So it's still early in the stage. However, it's getting better and better. So with regarding to the patents in China, it's a first-to-file system, and just like in the U.S. now. Also, China's patent system recognizes the same, grant you the same rights as in the U.S., which is, allowing to make, use, offer to sell, and import. Also, China's patent system, use the same standard, which is for patentability, which is, novel, has to be novel, and has to be non-obvious. Where in China's case, it's specific. Actually, they call for inventiveness, and then lastly, it has to be useful, utility. There's utility. So those are the similarities, but then there's differences. The main differences is in China, the invention patents. The invention patent is the same. The type of patent that I'm talking about is the invention patent is the same as in the U.S. in terms of terms, which is good for 20 years, and there's a substantive examination. Whereas for utility models, where the invention, is considered small step, improvement, for example, they are there's no substantive examination, and it's a faster registration system. Where, however, it's give you a shorter term of protection. Let's see what else. So there are also other differences in terms of between comparing the patent system in the U.S. and China. One would be there's no very limited ability in continuation practice in the China patent system, and very strict about introducing the new matters, and also very strict about introducing new claim combinations into a pending application, which means, all this means that you have to get it right in the first shot when you file your application. Let's see what else. So talking about all these patents, so how do you file patents in China? Basically, there are three approaches. One, you file directly in China. You have a 12-month domestic priority. And the second way of filing patent would be filing in the U.S. And then you have a 12-month, and then you file within 12 months. You file PCT in China, so then still you can get your invention protected. So the last approach would be filing a PCT application designating China, and so where you would enter the Chinese national phase within 30 months. So every 30 months, you can still have a 2-month extension for a fee. So these are the high level of introduction about Chinese patent system. About the trademarks in China, again, it's the same first to file system, just the same as in the U.S. It's important to know that there's no common law protection because China is a civil system, so there's no common law protection for unregistered mark, and so only in other words, only registered markets, trade services can be protected under the China trademark system. One thing we'd like to point out is in China, the trademarks, in terms of protecting, should have been more thoughtful about how possibly the different permutations in terms of using all the different language, Chinese, English, and Pinyin, to make your mark. Also, to be careful about the others, using your mark in a slightly different way, but still, confusing to people about, your goods and, source of it. Basically, the mark is an identifier for your source of the goods and the service. So by avoiding, you have to be careful so other people can, just switch one letter or something to make, you know, 山寨, so to speak. Let's see. So that's that. And then there's the domain, specifically, there's domain name protection. I mean, there are, just like in the US, all over the world, there's, you know, domain name squatters. So you have to be thoughtful, you know, as a business for your domain name protection, especially given nowadays there's so much, you know, going